With the pandemic comes the potential for an immense amount of litigation. That is the topic of my discussion today with Jim Swartz. He is an employment litigator with Seyfarth Shaw. Hello, Jim. Welcome.
Hi, Bob. Thanks for having me. Good to be with you.
So we're going to be discussing a new report on emerging trends in COVID-19 employment litigation. I want to talk about what are some of the details there, but let's start out by asking what types of litigation are so far emerging from this time?
Well, we have undertaken an effort to start to track the employment litigation that's been filed across the country. In that area in particular, we're seeing a lot of lawsuits that focus in a few areas, at least in the initial wave of cases that we've seen. The first, not surprisingly probably, are cases that relate to the working environment and employees claiming that they have been placed in a workplace that is unsafe for some reason because of the COVID exposure possibilities.
Mm-hmm.
The second type of claim we've seen quite a bit of early on are claims of either failure to accommodate a disability or failure to accommodate a COVID-related absence. We've seen some discrimination claims that have come along related to disparate treatment or treatment of individuals in certain classifications. For instance, age claims where employees are claiming that they're being treated differently because of their age under the COVID circumstances. And then finally, one of the other big areas are wage and hour claims. As you know, a lot of employers are doing different things with their employees. Employees are working from different locations or working from home, and it is bringing to light a number of issues they're having with how they're being paid. So those are the major types of claims we're seeing early on in the employment area.
That's a lot to bite off all at once. I would think that an employee bringing a suit for having contracted the illness would have a pretty heavy burden of proof to show that the illness was indeed contracted on the job. I mean, is that even possible to determine where they got it from?
Yeah, it's a difficult road to hoe, I think. What we're seeing for those types of claims is that they're starting out in the state courts. State courts tend to be a little bit more, for lack of a more scientific term, loosey-goosey in terms of their pleading requirements. So we're seeing them pled as negligence claims, in some cases wrongful death claims. But as you correctly point out, Bob, I think the big issue for those types of cases will be issues of causation, how the employee contracted the condition, and whether or not it was reasonably foreseeable for that employee to be at work in a position where they might have become exposed. So those are a difficult area.
So even if they didn't contract it on the job, if you can show that the employer did not take measures to prevent them from contracting it, if they didn't have safe distancing, if they didn't have plexiglass, if they didn't have masks, if they didn't have sanitizers, that connection might be enough, you think, to establish a case favoring the plaintiff?
These are traditional notions of negligence. What exactly is the standard of care that an employer owes to its employee? Typically, those are framed in terms of OSHA requirements and different types of state and federal regulations about workplace safety. So employers have a strong case to make wherever there's a situation where they are A, complying with those particular guidance and regulations, and B, where they're nowadays going above and beyond, which most employers we're seeing are taking pretty extraordinary measures to make sure their workers feel safe and comfortable in the workplace.
Certainly, I think a lot of them would be erring on the side of safety. But I find a very interesting topic that you just brought up, and that is age. I mean, in the pre-pandemic era, we experienced quite a few age discrimination suits. In other words, older people claiming that they were being discriminated against because they were older. Now it seems that it's exactly the opposite. Are older people actually demanding more attention paid to their situation because they are considered to be more vulnerable to the disease?
Well, the EEOC early on in the pandemic actually issued some guidance on this particular point. What they were concerned about were relatively well-meaning employers who were saying to their older workers, you can't do a particular aspect of your job because we're concerned that you might be more susceptible to a serious illness if you're exposed to COVID and contract it.
Mm-hmm.
So what the EEOC was cautioning about was not to make blanket rules about older workers and whether or not they can work under the same circumstances as younger workers. because that could potentially, in the eyes of the EEOC, lead to situations where older workers are deprived of opportunities to be promoted, opportunities to have certain job assignments. And so that's the types of claims that we are focused on here, where you have discrimination claims where an older worker claims that they're being deprived of an opportunity because of a perceived susceptibility to COVID.
Yeah, this may seem like a silly question, Jim, but I have to ask it. I'm wondering if there actually are any cases of workers who are working from home who contracted COVID-19 away from the workplace and yet somehow are trying to make the connection that they got it in connection with their job in kind of a workers' compensation type environment. Is that even a possible cause for action, or at least an attempt to bring that to a court?
Yeah, typically we haven't seen them phrased like that. We've seen a number of cases that have had to be reported by an employer because it's not clear whether or not it is an issue that was contracted while at work. I expect, and one of the things we're anticipating is that as businesses open up business travel, for example, if an employee is sent on an assignment in a remote location or some other location and they contract it while they're working, that could be a workers' comp issue. And of course, there's a whole separate body of law that tracks those types of issues and would be the framework for analyzing whether or not the employee has a claim.
In a class action, in this particular case, what constitutes a class? Could it be just anyone who contracted COVID-19 over multiple workplaces and employers, or does it have to be people within the same space? What is a class in this case?
Well, the classes we're seeing are typically related to one particular type of claim. So let's use wage and hour claims as an example. So a class would have to be a group of employees with the same employer who are claiming that they have the same grievance against the employer. And they, of course, the federal standards and state standards under procedural laws govern whether or not they can maintain it as a class action. But typically you'd have to have, at a minimum, you'd have to have common claims for the same employer and that they'd be susceptible to redress as a group.
There are privacy issues in the workplace too that I imagine have great relevance here in terms of breaking someone's privacy by claiming they have the disease or they don't have the disease or something. Are those emerging as causes for litigation as well?
Those cases have not been in the bulk or the biggest group of cases that have been filed to this point. They tend to be background for the types of claims that we're seeing. There's been some guidance related to whether or not employers can use temperature checks, for example. Many employers have implemented those. There are a number of other issues related to identifying individuals who have been exposed or contracted the illness. And employers what we caution them to do is be very careful about what they're disclosing about employees in the workplace who may have contracted it, mainly for the purpose of identifying others who may be at risk. We have not seen a flood of litigation on that particular issue at this point, though.
Certainly, I can't imagine that an employee would have the basis for turning down or rejecting a test at the work site. I imagine that would be that an employer would be on solid ground, making that a condition for their coming back to work.
There are a number of different processes that our employees are using at this point in terms of whether they actually have to have a negative test before they can return to the workplace. Many employers have done that. That doesn't seem to be an area of great litigation risk at this point. Temperature checks, certifications, many employers are using those. Those are very low risk from a litigation perspective. As a general rule, the more invasive the request by the employer about the worker's condition or what their health status is, the more likely it is to raise litigation concerns. And at this point, identifying whether the employee has the disease or not, or whether they have symptoms of the disease or not, pretty much are low-risk situations.
Now, these are early days from the standpoint of legal, how long it takes for a case to get through the courts if indeed it does go to trial. So maybe we don't have that many examples of this, but to what extent, how friendly, how open are the courts? Are both juries and judges, in your estimation right now, to claims being made of this kind?
Well, that's a great question. We're a long way from a jury trial on any of these issues. It'll be a fascinating area to explore as we go along. I would say, though, that when you think about juries, juries tend to relate to things that happen to them in their lives. When you are picking a jury for a trial, one of the things you're trying to identify is what are their life experiences? What do they know? And like it or not, I think one thing that has emerged from this pandemic is that everybody's a quasi-expert about it, and nobody really agrees on it. So I think what you're going to have is juries who are very, very familiar with the terminology. They're going to be very, very familiar with the challenges that both employers have, that employees have. It may well be aligned along geography, rural versus urban areas that have experienced significant outbreaks and those that haven't, those sort of issues. So I would say that the more creative, the more reaching a claim tends to be in terms of either causation issues or the breadth of the relief the plaintiff is seeking. The broader it is, the more fringe the theory of liability, the less likely courts are going to be to letting those claims actually go to juries. But I think juries are going to be very interested in these types of claims. But like I said, we're a long way from jury trials in a lot of places.
And when we get there, though, won't it be interesting to see what happens during voir dire, during the questionnaires of jurors determining their suitability for sitting on the panel in the first place, as to whether or not the prospective juror has had the disease or not? That might be actual automatic grounds for a challenge by one side, or that might be a requirement for conclusion of the jury in the minds of another lawyer. I guess you have no sense of how that would play out.
Well, that's a great question. We've been sort of kicking it around amongst those of us who are in the courtroom. And one of the things that, maybe that first question isn't even enough, because you could have COVID and have no meaningful impact. You might not even know you.
How bad was it? How much did you suffer, or your loved ones suffer, or anything like that? Have you experienced the death of any loved ones as a result of this? All that would be big questions.
Absolutely. Have you lost your job because of it? Did your employer lay you off? All of those sort of questions are
So real quick, obviously the best situation in litigation is to avoid it altogether. So what are some proactive steps that you are advising your clients, employers, or employees to take in order to head off the possibility of infection in litigation in the first place?
Yeah, I know you talked to one of my colleagues on another episode, and we have done a lot of work with employers on the return to work process. One of the things that we're finding is that employees who know what's happening and know what the plan is and know what the contingency plans are tend to be much more comfortable. They tend to be much more flexible when it comes to things changing in the workplace. I think people in general understand that we are in an unprecedented situation here, and that when an employer communicates rules about how to return to work, what your hours are going to be, how you're going to be paid for it, all of those sort of things. If the employee has a sense of how it's going to work and understands that it could change at a moment's notice, they tend to be more flexible and responsive to employer workplace policies around COVID. So communication is number one. I know a lot of businesses have been asking questions about things like liability waivers. Those tend to be very difficult to enforce, and they tend to be driven on a state-by-state basis. And then finally, the other thing that we are talking to all employers about is making sure that they have a good way for employees to communicate back to them. It's not just a one-way communication process. So as employees experience things like disruptions in their personal life that are occasioned by COVID, employers need to hear about that so that they can tailor their workplace policies. For instance, maybe they extend their accommodation process beyond the typical disability accommodation and turn it to something that's not necessarily a disability, like fear of COVID exposure. So those are the types of things.
Well, some great tips, Jim Swartz of Seyfarth Shaw. Thank you so much for helping us understand in a very confusing, very early world of litigation, just what's going on in the pandemic and what might happen going forward. Thanks very much for being with us. Appreciate it.
Thanks for having me. Good to talk to you today.